going to go through these segments, I call them. I'll stop and pause for questions. Some of this might be like a refresher. You already know it, and hopefully some stories that are some illustrations. The goal is to focus on a typical residential sale. The common issues that you see related to the deed and mortgage, and the title requirements and curatives. I'll discuss the deed, the mortgage, and recording. Remember, gap coverage is standard and automatic in New York. And I'll spend a few minutes as that relates to title. Particularly, I'll touch on the estate planning area. We'll talk about mortgage payoffs, standards for open mortgages that are ancient, resources for duplicate discharges of mortgage that are not ancient, judgments, and the importance of affidavits. After a 10-minute break, I'll jump into powers of attorney and title policy coverages. I'll highlight that as I go through the topics as well. This is a quick snapshot of me. I'm a Western New Yorker. I've been with Fidelity since about 2008, starting to be too many years to count. And essentially, before being with Fidelity, I practiced in real estate almost primarily, exclusively, I should say. I'm going to also touch on the amended Tersa rate manual that became effective October 1st, bringing New York into the practice of the rest of the country. We're using the Alta 2021 policy forms now. Some coverages have been expanded, and there's many new endorsements. The most important change to this amended rate manual, as you've probably already heard, is that affirmative coverage in Schedule B that we've all used forever is no longer allowed. You are often the person making the decisions, and when this is happening prior to closing, you have time to contact Chautauqua Abstract, but when you're at closing, you don't have that luxury. If an issue is presented at closing, it's usually based on the deed and mortgage, which are the underlying reason for many claims. Many people seem to believe that's not true. So certainly we do have claims that are based on search errors, but many claims are based on that deed and mortgage. And so that policy is really very important to your client, and by extension, it protects you. My goal is to help you by adding to your knowledge. I have statutes and illustrations and examples, all to allow you to spot the issue before there's a potential claim. The idea is to prevent the problem and reduce time spent on a file after closing. I'd also like to highlight those policy coverages, whether it's in the policy or the endorsement. So there's a lot to learn. I think we're still in a transition and learning curve with the really very significant changes to the rate manual. I'm going to start with the closing documents, the deed, hopefully to be insured, and the mortgage. Even if the deed is not being insured, the underlying deed is critically important to the loan policy, and that would be covered risk number one. I'll talk about that a little bit more. So who is the grantor in the deed? Is it an estate? The grantor clause should contain the name of the fiduciary and the name of the decedent, along with the county where the surrogate file was established and the file number. This is especially important when the surrogate file is in one county, the county of the decedent's residence, and the real property is in another, for example, with a second or seasonal home. In those instances, there's no record of death of the owner in the county where the real property is located. We have surrogate court records online now, so you do not have to record the will or the petition or the letters in the office where in the county clerk's office where the real property is located. The idea is to recite the county where the surrogate's court file was established in your grantor clause at a minimum, so that you establish the authority of the executor or administrator to convey. Also, have the names of the heirs searched in the county where the real property is located. Again, should that be different than the county of the decedent's residence. So that's not to say that a fiduciary appointed in another state can convey New York real property. If the fiduciary was appointed elsewhere, an ancillary proceeding is required in New York. And I refer you to EPTL 3-5.1 and Article 16 of the Surrogate Court Procedures Act. Certainly, we have full faith and credit in this country, but when it comes to real property, the law of the jurisdiction where the real property is located controls. And so a deed from a fiduciary appointed elsewhere in the U.S. is not acceptable. An ancillary proceeding in New York is necessary in order to convey marketable title. That's also not to say that a small estate with a voluntary administrator can sign a deed to convey title to real property. A small estate is under Article 13 of the Surrogate Court Procedures Act, and it's not sufficient authority for a decedent who owned real property. Instead, that's authority only for personal property under $50,000 in value. Is there more than one executor? If so, we look to EPTL 11-1.4. We require all executors to sign the deed. Now, there is an exception to that in the statute where you have a bona fide purchaser. The Fidelity position really is to avoid that analysis and to have all executors sign the deed. If not, there is some title room, I guess, and analysis, and the statute goes on to say that it would be 10 years before a deed signed by less than all the executors was considered valid. And importantly, has the executor signed individually? We should not be using powers of attorney when there is a fiduciary as your grantor. Has the seller's attorney provided a copy of the decree and letters? Those, as we know, do not expire. And have they provided a currently dated certificate of letters? Currently meaning 6 months from your closing. The letters are dated the same date as the decree, and most often your closing is more than 6 months from then, because as we all know, it takes a lot of time to clear out anybody's house and settle up on estate debts, and assets are really not distributed quickly. So that certificate of letters, again, is what we're looking for to rely on current authority of the executor to convey, and that's in Section 703 of Surrogate Court Procedures Act. There's a sample certificate of letters in your materials, just so you have a look at that. Is that the common practice around here? I found it differs throughout New York. No. Is the grantor an estate with a will where the real property was specifically devised? You'll be aware of this because the specific devisee should be identified as the vested owner in the Schedule A of your title report. The specific devisee must sign the deed, and the grantor clause should identify the grantor as such, and also, again, include that surrogate court county and file number. An executor's deed does not convey title where there is a specific devise in the will. We do see this from time to time, and it's, many of these title issues are discussable, debatable, negotiable, if you will. This isn't one of them, I would say. At the time of probate, title will vest in the specific devisee, and that is the only person who can convey title. The Burke case is in your materials. It explains a little more on this point. And should you be examining title, and in that chain of title you see an executor's deed where there was a specific devise, the requirement really would be a deed from the specific devisee before your next transaction. So back to the closing, if you have an administration file where the decedent died intestate, only the appointed administrator has to sign the deed. The heirs do not have to sign the deed. The administrator has the power of sale under EPTL 11-1.1, despite title actually being vested in the distributees. Again, that power of sale of the administrator is what controls. We received, I would say, many questions on this, and we even had a claim where the underlying deed into the borrowers was signed by the administrator only, and there happened to be one other heir, a brother. The attorney in New York, who had begun foreclosure versus the grantees, and they were bona fide purchasers, insisted that the other heir sign the deed. They'd started a quiet title action. Really, this was completely unnecessary. The administrator only signing the deed, particularly to a bona fide third party for full consideration, is all that is required. I mentioned covered risk number 1, which is coverage to the lender and to the insured owner if you buy an owner's policy, against loss or damage by reason of title being vested other than as stated in Schedule A. So the underlying deed, being critically important where there is a loan policy, is grounded in this coverage, and this is really what everyone knows almost intuitively. That is, only the owner can execute a valid mortgage, only the correct owner, all the owners, and no owners having been missed or unfound, if you will. And that applies, of course, to the sellers as well. So this is another illustration that's been going on for the last, 3 months. We have a deed from all heirs of a deceased owner to a third party. That third party, had a purchase money mortgage. That mortgage is in the process of being assigned to Sunny Mae. Now, there's a loan policy certainly showing the grantees, third parties, as the vested owners in fee simple. And Sunny Mae will not buy this loan. They've questioned the validity of the deed. At one point, they said, the seller really has to go to surrogate's court to be sure that the decedent's estate plan was carried out and her intentions were realized. So this has been a little bit aggravating, to say the least. It's been some back and forth. Convincing Sunny Mae that the heirs can indeed convey real property, that the title company that produced that loan policy did the necessary due diligence to capture all of the heirs. It's been an uphill battle. At this point, Sunny Mae is asking for an attorney opinion letter. So we've replied and said, well, who's going to pay for that? Are you going to include that in your closing instructions for every time an heir a deed from heirs, that is in the closing? And I wish I could give you a resolution. It's just been ongoing. But I think the point that I'm trying to make here is that the policy ensures the lender of the vested owners. There's no reason to question it, but that's our reality. So if you have a grantor that is a trust, the name of the trustee or co-trustees of the full name of the trust should be the grantor clause, even if the vesting deed identified the trust itself without naming those trustees, which does sometimes happen. All co-trustees must sign the deed. Again, that's a Fidelity policy based on EPTL 11-1.4, and must sign individually, not by agent under a power of attorney. Beneficiaries of a trust do not typically, in most circumstances, have to sign the deed. So just who is the trustee or co-trustees? Our job is to find out so that the correct person or persons, meaning the person or persons with authority to convey, do so. This is done prior to closing, but I thought a few minutes on this was a good idea. I'm sure you've encountered any one or more of these scenarios. Perhaps the recorded deed names the trust itself, so you don't know who the trustee is. There's been a death of a trustee, or there's been an amendment to the trust changing the trustee. When the the recorded deed names the trust itself, and again, that's not what we recommend, is not really an acceptable means of holding title. You certainly ask for a full copy of the trust to examine who the trustee is. There's an exception to that rule of not naming the trust as a grantee, and that's in EPTL 7-1.18, for those trusts where the trustee and the beneficiary are the same person. That's an off-record document, so again, the practice we recommend is to name the trustees as the grantee. And later, when they will convey out, you certainly have that evidence. If the trustee has died, again, review that trust. Is a successor named? Is the intent of the settlor of the trust as to the number of trustees to be in place to serve recited? If there's been an amendment and a new trustee appointed, do look at that carefully in terms of the date, and we even go so far as to compare the signature on the amendment two signatures of that settlor on prior recorded documents. For a conveyance from an estate and from a trust where the grantee is a third party, the full consideration should be stated. And if not, a deed recital explaining that really should be in place, and I'll speak to that in a few minutes. So if we have an entity as a grantor, you have an LLC, a corporation, a general partnership, or a limited partnership, the grantor clause should match the name of the entity according to the recorded vesting deed. And if there's been a name change, a conversion, or merger, that information should be stated either in the grantor clause or in a deed recital. The signature block in a deed from an entity is very important. Again, it's our job to identify the correct person, meaning the person with authority, proper authority to convey. When an LLC will convey, is the individual person's name stated in that signature block the name of the person you see in the operating agreement? And is that person's office or affiliation or capacity also stated? It drives me crazy when the signature block just has an individual name and you don't know if it's a member, a manager, a vice president, or what. Just a pet peeve. Is that same person identified in the resolution authorizing the sale? Is the resolution itself signed in compliance with the terms of the operating agreement? So sections 401, 402, and 408 of the LLC law, and the Calico case, and LaSalle Bank versus Allied. Those cases are in your materials for more on this. When a corporation will convey, is the individual person's name stated in the signature block of the name of the corporation? And do you see that person is an officer in the articles of incorporation or bylaws? Is that person's office or affiliation also stated in the signature block? And is that person identified in the corporate resolution authorizing the sale? You have a general partnership, have all the partners sign the deed. With a limited partnership, has the general partner sign the deed. And I did pull a sample signature block for limited partnership for an individual general partner and a corporate general partner. That's in your materials. So I have a couple of deeds where an LLC will convey. Everybody see that okay? We've got PBL Group LLC as your grantor. Jane Smith is down there as authorized signatory. The seller should provide a resolution. We've got Jane Smith stating that she is authorized to execute the deed and other documents for the sale of the premises. The operating agreement identifies a sole member, and that member's signature on the operating agreement is a match to the signature on this resolution. So you think we're in pretty good shape here. The operating agreement, a resolution, and a properly drafted deed. However, nowhere in that operating agreement is Jane Smith identified, so we have an apparent stranger. At Fidelity, we would want some minimal explanation of the relationship between Jane Smith and the sole member. There's no requirement that she be a manager or any formal employment arrangement, but something to explain everything that we have documented here. And I'm sure the seller's attorney would provide that. So in this example, we have, I thought this was kind of clever and cute, Fresh Start Houses, LLC. And there they are as a grantor. By the way, we do recommend when an entity is either a grantor or a grantee, the state or jurisdiction that it was established in be included. So that a better grantor clause would have been Fresh Start Houses LLC, comma, a New York LLC. So when we get to the signature block, we have Russell as authorized person. So who is Russell Doe? The operating agreement in this one had a sole member. His name was Matthew. You would expect a resolution signed by Matthew identifying Russell as authorized to sign the deed. In this scenario, and I don't make these up, by the way, these are things that cross my desk, we had a New York statutory power of attorney. Matthew was our principal, appointing Russell as agent, That was Matthew's signature there. This is the primary example of what does not work. And I think it's fairly common, so I wanted to have these, documents up on the screen. The operating agreement, and only the operating agreement, is the basis of authority for the entity to convey. Matthew, in his individual capacity, can handle his individual affairs with that New York power of attorney, but when it comes to the entity, only the operating agreement can be looked to. Most of those do not have a reference to using a power of attorney. This one, in fact, did not. So what happened here is the member, Matthew, happened to reside in Florida, just printed the deed there, found a notary public, sent it back up to New York. Again, that statutory power of attorney form is meant for individuals in their individual capacity. And that's really found not by what I say, but in the General Obligations Law 5-1501 2K. And that defines a principal as an individual over the age 18. That individual certainly can be a member of an LLC or a shareholder of a corporation, but that power of attorney cannot be used to allow the agent to sign a deed or any other documents on behalf of that entity. I'll spend some time on grantors who convey by power of attorney in the next hour. For now, I'd like to just point out the signature block when a power of attorney is used. And that's spelled out in General Obligations Law 5-1507, and the relationship between the agent and principal has to be disclosed. I think we're all accustomed to this. So here's an example. Mildred was our principal, and Lee Michael was her agent under the power of attorney. So take a look at the signature block. Lee Michael, comma, POA. And I know it's a little thing, another pet peeve of mine, but he's an agent. He's not a POA. The POA is the document. Mildred is the principal. Lee is the agent. So just a tip for the correct signature block, and also in the acknowledgement, Lee Michael as power of attorney, you don't need any capacity of the individual. That's otherwise accounted for in the acknowledgement language, so it would just be his name individually. Oh, I'm sorry, I went backward here. You probably noticed down here I'm saying affidavits cannot be signed by the agent. Again, I'll kind of emphasize this later, but I wanted to, add emphasis now. An affidavit cannot be signed by an agent under a power of attorney. An affidavit is a recital of facts based on personal knowledge. So only the principal has that knowledge. And an affidavit is confirmed by oath or affirmation of the party making it. And again, as an agent, a separate person, simply cannot do that. Okay, I'm going to move on to deed recitals. So again, we're in the typical residential closing, and the purchaser is a third party. Let's say the seller is a trustee. The deed at closing from the trustee really must state the full consideration, and the same is true for estates. There are several scenarios, however, when, particularly in estates and the grantor is a fiduciary, where there's less than full consideration. So let's say you have a sole beneficiary of an estate who's obtaining a loan for a cash-out refinance. The executor's deed would have this simple recital. The conveyance is being made to carry out either the terms of the will of the decedent or to effectuate the distribution of assets of the decedent who had died intestate. Again, the idea is to explain away the no consideration deed, particularly because the deed is coming from a fiduciary. You may have several beneficiaries or distributees, one of whom will be the grantee, and that person applies for a mortgage. And so you've really got the one sibling buying out the others. The deed recital we recommend there is that the conveyance is being made for full consideration due to the estate. So this comes in also with transfer tax. Now, transfer tax is not a covered item. There's no coverage in the policy, but it's important and significant, so I'll just spend a minute here. Real Property Tax Law 1401E states that a conveyance of real property shall not include a conveyance pursuant to a devise, bequest, or inheritance. So in other words, conveyance for tax purposes does not include inherited property. There's an exemption on the TP form, and that's Schedule B, Part 3 and K, and that's in your materials. When the conveyance is one sibling buying out the others, the exemption applies to the percentage of the share of the grantee only. The other percentage is a conveyance for which consideration is being paid. Yes, it's inheritance, but it's a sale of that inheritance, and so transfer tax is due. This type of conveyance is often categorized as a refinance by lenders, and when closing comes along, everybody's shocked that there's transfer tax due, and that throws all the disclosures off, and you have delays and chaos. So I just bring this up now so that if you recognize this early enough with your client, you can address that and avoid the closing chaos, as I call it. On the examination of title side, when a no consideration fiduciary deed exists and there's no deed recital explaining it, most often we call for a confirmatory deed. But you really can take a look at the total circumstances before you have to take that step. We take a look for transfer tax paid. Perhaps there was a purchase money mortgage recorded at the same time as that deed. And if that deed was recorded more than 10 years ago, we can rely on the RPAPL for that presumption of validity. And there's always Randy to call if you have questions. Moving on, if you have a corporation that is conveying, every deed from a corporation should specify a deed recital that it's either in the ordinary or usual course of business, or made pursuant to resolution adopted, or made with unanimous consent of shareholders. And this is based in the Business Corporation Law 909, and that's in your materials as well. You may see a deed recital that the conveyance is not all or substantially all assets. And yes, that complies with 909B, but we're looking for one more step of a deed recital for really the authority issue. So if you have a builder, new house, new construction, certainly the ordinary and regular course of business is the correct recital. Otherwise, you're looking for one of the other two. So I'm going to go on now to the grantee clause. I'm sure you know that the choices when you have individual grantees is either a tenancy by the entirety, joint tenants, or tenants in common. And the best practice is really to include or state one of these. If none are stated, a tenancy in common is presumed, and that's fine. But I think the better idea is to put in writing what is intended. Here's what can happen if your client calls you in the future and there's no tenancy clause. We had this question come in. We had a couple who bought a house some years ago, not married at the time, and nor were they ever married. There's no tenancy clause on the deed, so again, the tenants in common is presumed. Several years go by, one of them dies, and there's no heirs. That deceased person's half ownership cannot be conveyed. The other owner had no right of survivorship, and the other owner, not being a spouse, could not convey as an intestate heir. Let's say the other owner did have heirs, the one who died. Those persons are now co-owners with the surviving owner on that deed, and let's just face it, sometimes that's less than desirable. That all-important tenancy clause. I can't tell you the number of stories we have encountered on that. So I'd like to point out that if the grantees are married at the time of closing, EPTL 6-2.2A provides that a conveyance to married persons creates in them a tenancy a tenancy by the entirety, even if there is no deed recital. But I'd like to emphasize that it has to be true at time of closing. If a couple gets married after closing and there's no tenancy clause, they're going to remain as tenants in common. Again, sometimes less than desirable results as time goes by. A tenancy by the entirety does not arise later due to a marriage that takes place after closing. 2 or more individual grantees as joint tenants will certainly have that right of survivorship. An equal percentage of ownership proportionate to the number of owners is presumed. 2 or more individual grantees as tenants in common, either stated or with nothing stated, will occur, and they will not have the right of survivorship. Instead, when an owner dies, his or her share passes through his or her estate. An equal percentage of ownership proportionate to the number of owners is presumed. On a tenancy in common, a different percentage can be stated and is recognized. For a trust that is a grantee, again, I think I pointed this out earlier, we recommend that the name of the trustee of the trust be stated, because the trust itself is really not a legal entity that can hold title to real property. It's just a name denoting a legal relationship or an agreement between the grantor of the trust and a trustee. When an entity is a grantee, again, include the name in full, exactly as it is in the state filing, and include the state where the entity was established, whether it's a New York LLC, a Delaware corporation, and so forth. It seems like a small thing, but do check the spelling and the punctuation. You can use the words limited liability company. You can use LLC, all in capital letters, no spaces, no periods. You can use LLC with a period after each letter, but no spaces. I know I'm talking minutia here, but it matters, it counts. Any difference, as minor as it may be, can be a distinguishing factor, and you don't want the call post-closing to get a Scrivener's affidavit, a correcting deed, or what have you. Confirm that the entity has been filed with the Department of State and filing fees have been paid. If not, it's simply not an entity. Can't hold title to real property. You'd have to really reschedule if you encounter that. Or if you don't, you'd have a confirmatory deed sometime down the line, something I'm sure you'd rather avoid. I had this question come in just yesterday. Can an individual and a trust be joint tenants? And I think the person knew the answer, they just wanted confirmation. They certainly cannot. Only individuals can be joint tenants. The trust and an individual would have to be tenants in common. I think some creative estate planning was probably going on in the background there, but something that couldn't be established by deed. So this was an interesting scenario. Think about these facts in a couple of ways. Would you prepare and record this deed without a deed recital? And then think about a future title exam too. So we have Richard, who died in 1989 in Erie County, and his will is probated there. The will leaves all the rest, residue, and remainder to his wife Janice and names her executor. And if Janice is predeceased, the will goes on to say that rest, residue, and remainder will go to his 2 children, Alan and Susan. Alan and Susan are the successor executors. The petition shows, and the surrogate file shows, that Janice predeceased, and there's a surviving spouse. So Richard remarried somebody named Elizabeth. Time goes on, and in 2020, the title exam shows that Alan and Susan, as co-executors, signed a no consideration deed to Alan, and that's for property in Chautauqua County. They relied on those 1989 letters testamentary. So Alan is now selling. That's the title file. Let's say you represent the grantee, the proposed purchaser. How many issues, right? We have a spousal right of election going on here. We need some answers there. We have very old letters testamentary. Whether you can get a certificate or updated letters, something is needed there. So much time has gone by. There's a no consideration deed. I mean, perhaps this distribution was part of, perhaps the deed conveyance was part of the estate distribution, but we can't tell from the record. You're going to be asking for more here. And to the earlier point, this property is in Chautauqua County. There's no record of death in Chautauqua County of Richard. It's up there in Erie County. So we can search the records online and find that, but your grantor clause in Chautauqua County really ought to recite the surrogate court information from Erie. And I think I've come to a point where I can stop and have a chat or conversation or questions. Anything come to mind?
Curious, how did you get Warren County?
I'm sorry?
And I'm looking at the scenario, and at the bottom, in Warren County.
Oh, I use this example in more than one presentation, and that's my typo. Yeah, sorry about that. Yes?
Would you also have to file or record a copy of the letters from the county?
That was the practice for many years. It's not harmful, but I would say it's not required. Anything else? Okay, I'm going to talk about the insured mortgage for a few minutes and the borrower and the grantees on the deed. So most often you have a married couple who will be the grantees. Sometimes one spouse does not have to sign the note. Their income is just not necessary to qualify for that mortgage loan. But both spouses will be grantees or owners on the deed, with the tenancy clause, husband and wife, or tenants by the entirety. The person who's not signing the note but signing the mortgage is referred to as the owner non-borrower. And the bank attorney might say to you that owner non-borrower does not have to sign the mortgage. Maybe you've experienced this. It is technically true, but the consequences are significant. It leaves the bank subject to the interest, that is the ownership interest of the owner non-borrower. The mortgage signed by one but not all owners is not a nullity, and that one owner is not prevented from mortgaging his or her rights in the property. It's the result that matters. The result is that the mortgage is secured only up to the interest of the owner who did sign and left subject to the interest of the owner who did not sign. So what that means is, at closing, you would have to include an exception in the marked up report. Just simply saying, subject to the ownership interest of the name of the person who is the owner non-borrower who did not sign that mortgage. The Castleton holding case in your materials is very interesting on this point. So let's assume you've explained this and the bank attorney's now convinced you're right and they're going to have both owners sign that mortgage. There could be, and often is, a concern that doing so creates a personal liability for the debt in the owner non-borrower. And that can be solved with some language. They're in the language is in the Castleton case. There's a Charles Schwab versus Winnetech case from 2020 on this point that also has language really to the point of saying, notwithstanding any provision herein, borrower is not assuming any personal liability for payment of the debt secured. I have another illustration about this, a kind of a twist. So here, I don't have it on the screen. We had a 1998 deed to a husband and wife. Again, I don't make this stuff up. I just get this in my day-to-day duties at Fidelity. They were divorced, and there was no deed from the wife to the husband, as was called for in the separation agreement. In 2018, the husband only signs the mortgage. In 2022, that lender foreclosed. The lender was, I'll say, smart enough, in quotes, to serve the wife with the foreclosure papers. The referee's deed is recorded back into the mortgagee, into the foreclosing lender, who is now selling. So what do you think the title company is going to require? A deed from the wife. She never pledged her ownership interest, certainly. They had been divorced, but she never conveyed her ownership interest. Service on the wife in the foreclosure really accomplished nothing. You can't fix what happened that long ago in this way. If she won't cooperate and sign a deed, The only option or choice I could come up with for the people calling was, you'll have to make a claim based on your loan policy. Let's take a look at your loan policy. Does it have an exception for this ownership interest? Again, the wife had never signed a deed after the divorce. I guess you could look at it in two ways. If the exception is there, good for us, bad for them. If the exception is not there, good for them, bad for us. We'd have coverage. By the way, I think that actually had a very positive ending. The wife wanted nothing to do with anything and appeared in the foreclosure action, signed away any and all interest to the point where we were comfortable insuring from the foreclosed lender who was selling to our insured part purchaser. So I'll take a few minutes here on deed delivery. So we have our deed and mortgage signed, and we're going to go on to recording. Just a refresher on the basics, there's RPL 244, that a grant takes effect so as to vest the estate to be conveyed only from its delivery. We really don't have documentation of a delivery date in the chain of title, so we rely on the dated date of the deed as the presumed date of delivery. Delivery is the relinquishing of dominion and control, or giving up possession and control over the property and the deed. Delivery really must be unconditional. The human case is in your materials. It's very descriptive on this point and involves the dreaded scenario where the grantor dies before the deed is recorded. And I have a few of those scenarios too. So we're going to go on, of course, to RPL 291, the recording. A conveyance may be recorded in the office of the clerk upon request. Every such conveyance, not so recorded, is void as against any other person who subsequently purchases. So we all know that New York is a race notice state. Delivery creates and effectuates the conveyance. The recording is the all-important notice to defeat any other deed or instrument of the conveyance. So there's often a gap in time between the date and time of delivery and the date and time of recording, and we just call that the gap. The gap coverage, that gap is provided coverage in the title policy. From our point of view, we want that to be as short as possible, so don't let those documents sit. It's covered risk number 10 in the owner's policy. It's number 14 in the loan policy. Again, the coverage is for any defect in or lien or encumbrance on the title or other matter pursuant to those covered risks that has been created or attached or has been filed or recorded in the records subsequent to the date of policy meaning date of closing, and prior to recording the insured deed and mortgage. Unlike some underwriters, Fidelity does not require a gap affidavit or gap guarantee. Again, it's part of the coverage. So the actual practice does differ. I realize that, particularly in upstate New York, as my colleagues down in New York City like to call us. There's the traditional practice of holding the funds with or without an escrow letter until the documents are recorded. You've done your search rundown, your documents go on record however many days after your closing. That certainly eliminates the gap, and as title folks, we thank you very much for that, but it's not required. And it could lead to more than an argument, because again, the closing has occurred. Disperse those funds. The policy provides coverage for any risk in the gap before the documents are recorded. Have you experienced a search rundown where a new judgment, perhaps an increase to a home equity line of credit or some other document is found? Has the money been dispersed or is it on hold? If it's on hold, is there an escrow agreement? What are the terms? You see, it just spirals down and down. The idea under the law, the lien law, and the gap coverage in the policy is to disperse at closing. So these are the, I don't have them on the screen, but these are examples I spoke briefly about an undelivered deed, or let's say it's presumably delivered but not on record. This one is the middle of the road recording delay. So we have a deed from a mother to a daughter dated in March of 2021. The mother died in February of 23, and the deed was recorded the following month, March of 23. There are siblings. The daughter, who's the grantee on that deed, is now selling to a third party. Because there was a 2-year delay in the recording, the title requirement was for proof of valid delivery. Again, that deed was dated in March of 2021. That's the presumed delivery date. But that delay in recording raises a requirement that we're not going to rely on that presumption. We're going to question it. The family attorney had said it was an estate planning decision that was made. The deed was executed and retained by my office in accordance with the mother's wishes. Okay, we don't have to talk any further. I understand that that's not a delivered deed. We certainly don't have unconditional delivery. The mother's no longer alive. Even if she was, I don't think she could honestly say in an affidavit that she intended to unconditionally deliver. Nobody else could certainly say that credibly. So the result is we go back to the original deed of record. We ignore the deed that was recorded in March of 23. There's other ways, certainly, to accomplish whatever the client was intending there. This next one is the extreme recording delay. Again, I don't make these up. There we had a delay between the dated date and the recording date of 18 years. And the recording occurred 9 months after the mom died, same fact pattern. That attorney said she was fully familiar with the family and events surrounding the purposeful delay in recording the deed. All the children were fully aware of the deed and the reason behind it not being immediately recorded. And I thought, 18 years, that certainly isn't immediately. And this last illustration was from an attorney in the Rochester area. I call this one the estate plan gone wrong. So Richard and Liz are husband and wife. They own the house for many years. Liz is in declining health. The attorney prepares a new deed from Richard and Liz to Richard and a life estate to Liz. This one did not involve the children, just the husband and wife. That's dated in November of 2021. The deed was intentionally not recorded. If Liz died first, as was expected, the deed would not be necessary and would be shredded, since Richard would become sole owner by virtue of being the surviving spouse on the original deed recorded long ago. If Richard happened to die first, Liz would be the owner, but of a life estate, and due to her age, that value would be very low. In fact, what happened is Richard died first in July of 2022, and the deed was recorded in December of 2022. The family was selling to a grandchild, and while Liz was still alive, but again, with her health, the life estate interest was not a concern. In February of 2023 is when that was occurring. Because delivery, that is unconditional delivery, did not occur, even if Liz was competent, which unfortunately she was not, an affidavit would not cure this scenario. Liz then died in May of 2023. We treated the November 2021 deed as a nullity, leaving title as it originally was in the husband and wife. And unfortunately, with Richard dying first, the full value of the property was attributable to Liz, not a life estate value, and she was in fact receiving Medicaid assistance, which was a very significant chunk of the value of the property. So really the takeaway here is an executed but not delivered deed, one that is intentionally held off record and recorded after the death of the grantor, is not going to accomplish the client's intent. There are other avenues, such as a deed with a reserved life estate, perhaps also a power of appointment, or a will with a specific devise. The new Todd deeds are also a choice. But to the point, even a Todd deed has to be recorded while the grantor is alive. Should you see a title requirement of proof of valid delivery, most often the grantor's wishes were known to the family, and we have seen scenarios where all the family members do cooperate. Hopefully that is true for you. If not, call Randy, call us. We'll talk these things through with you so that marketable title can be conveyed. So any questions on this one? Okay, mortgage payoffs. If it were only simple, right? Rarely is anything simple in life, much less real estate. Simple, I mean, maybe there's one mortgage on the title given by your seller, your current owner. He's current, he's making payments, the payments are being made to the mortgagee of record. That would be great. Probably, 15 or 20% of the files you see. So what if you have a separate mortgage to HUD on the title report? Is the payoff to the first lender inclusive of the money owed to HUD? And in big capital letters, I will say, no, it isn't. These are known as partial claim liens based upon any of a number of several government programs. Those programs assisted homeowners both before and during COVID. And they were funds to either pay down arrearages or modify the first mortgage, resulting in a second mortgage to HUD. So don't ignore that mortgage to HUD on your title report as if the payoff of the first will also pay off HUD. Do not assume the payoff letter includes funds due to HUD. Again, I'm sorry, I'm repeating myself there. There is a website for these HUD payoffs in your materials. There was even a July 2024 press release from Alta indicating that although these recorded HUD mortgages, again, are recorded, they're not being detected. And these illustrations, I think, will show the point. There is so much detail in the HUD mortgage that one logically would think that it is inclusive of the first payoff, but it is not. So we have a 2010 mortgage to MERS and Bank of America, assigned straight to Bank of America in 2012, and a modification done in August of 2013. For some reason, that modification was recorded twice. There's a mortgage to HUD with similar dates. July of 2013 and recorded in September of 2014, a real unusual dollar figure. You've got the dates that nearly match, and you've got a payoff letter from Bank of America thinking that it includes the second mortgage to HUD. Again, the loan number and the name of the lenders and the dates are all a match. Don't let that deceive you. This illustration was with MidFirst Bank, and this was a 2005 mortgage with new money and a con mod in 2009 and again in 2011. Thereafter, there was a 2015 modification. Also in 2015 was a mortgage to HUD in the just over $4,000. The dates nearly match up, and the loan number and the name of the lender are referenced in the HUD mortgage, thinking that they're tied, but they are not. That HUD payoff information may be the most valuable of all the materials I sent you. I hope so, anyhow. What if you have a lis pendens on your Schedule B? And that is tied to the mortgage that will be paid off. A payoff letter is usually alone not enough unless it includes attorney's fees and filing fees. Those really should be looked for and asked about if you're not seeing them on the payoff letter where you have an open lis pendens. There may even be advances by the lender for taxes or insurance. You should scrutinize a payoff letter very carefully when you have a lis pendens and open foreclosure scenario. What if the payoff letter comes from a lender different than the lender of record? When a mortgage is assigned to a trust, you've probably seen, for example, Wilmington Savings Fund Society solely as owner trustee. Servicing is always done by another entity. So check the assignment for the loan number, check the payoff for a match to that loan number. I've recently learned that Nation Star Mortgage frequently records an affidavit of missing assignment, asserting that it is the current mortgagee. Check that affidavit for the loan number. Is another servicer issuing the payoff? Keep digging. More research is needed to connect that servicer to the mortgagee of record. Sometimes you've got a successor or merger scenario. If you can't find that, I would simply ask the seller, homeowner, if they've received an assignment of servicing letter at their residence, or just take a look at the most recent monthly bill. Aside from servicer issues, it is important to know, and they heard a scenario about this just last week, Mr. Cooper and SPS, they're called Select Portfolio Servicing, they are known for asserting that a payoff is short and thereafter destroying checks or claiming that the payoff checks were returned and in fact really nobody in the transaction ever received them. I even heard this from an agent that the Mr. Cooper payoffs, if you happen to pay off in the form of 2 checks instead of 1, they'll cash one and destroy the other, shred it. So try to avoid that if at all possible. What can you do with payoffs? Follow up. It's time well spent. It avoids the dreaded scenario that for whatever reason or claim that the seller's lender is making that it wasn't paid in full, time goes by and the seller's mortgage goes into foreclosure. Your client, the buyer, is now sitting at the property wondering what on earth this paper is that they've received in the mail. Hopefully, your client has an owner's policy at that point and the rest goes on. I'd like to point out Section 275 of the RPL that requires a lender to present a discharge to the clerk for recording within 30 days. There's a monetary penalty of $500 for failure to do so. The monetary penalty goes up to $1,000 if the discharge is not presented in 60 days. Or how about $1,500 if not presented in 90 days? Some attorneys have used this successfully, and to say that they are a hero to their clients would put it mildly. Again, the idea of the follow-up that I'm stressing here and making sure the discharge is on record is to avoid the claim scenario that I've dealt with a number of times. The third-party purchaser is in ownership and possession, receives some crazy foreclosure papers in the mail having to do with the seller's mortgage that for whatever reason was not paid off properly or allegedly properly, but there were some unsavory, I guess is the word, business practices of the servicer or lender receiving that payoff. Another point on payoffs is, are they being wired, right? So this is a huge issue in our industry, and here I'd like to quote a senior vice president in risk management from Fidelity. There is no insurance on the planet that covers funds wired to the wrong account. It is not in your E&O. It is not in any cyber coverage you may have. It was offered in the past. It no longer is. So you are the title examiner, title agent, examining counsel, whatever role you take, you're omitting a mortgage on the title report based on a wired payoff. The best practice is to become involved in that. You can't rely on another law firm to do so properly. We've had those claims. It's still ongoing, and the claims are a litigation nightmare. If you are engaged in wiring funds, speak to myself or Paula. We have outside vendors. There are answers to this problem, but don't go it alone. If you have a second mortgage, right, and the seller has a discharge bankruptcy, that's kind of an interesting scenario we run across. The seller might honestly believe that his debt has been wiped out by the bankruptcy, or that seller might understand that the lien of the mortgage remains, but stops making payments anyhow because He understands the second lender's not going to foreclose. There's a large first mortgage in the way, making it really impractical. The personal obligation to pay that mortgage was discharged in the bankruptcy. The lien of the mortgage on the property has not been discharged. Payments will remain as due and owing as a lien on the property, even if that owner is not making a monthly payment. Sometimes a monthly statement's not even being sent. These kinds of mortgages are quite often sold to collection, and these companies sit and wait. When they are tracked down and approached, the payoff amounts are really quite high, very shocking. If you see this scenario also, don't rely on the 6-year statute of limitations on second mortgages. You really cannot assume proper acceleration of the debt. In these second mortgage with discharge bankruptcy scenarios, you would need a bankruptcy court order that is made pursuant to a pond motion, and that can remove the lien on the real property of a second mortgage, but it's not automatic. You certainly wouldn't want to guarantee such a thing. You would need a payoff or that court order in that scenario. I'm going to talk about home equity lines of credit. Oh, okay. Why don't we take our 10-minute break?